Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book on the law of squatting. It's come to us from ROUTLEDGE. It's an interesting book. It's of a high academic standard. It's got a title, Moral Rhetoric and the Criminalisation of Squatting. And then it's got a subtitle, Vulnerable Demons. And it's been edited by three people, Lorna Fox O'Mahony, David O'Mahony and Robin Hickey. It's part of the Routledge, Taylor and Francis group of publications, and this one's a particularly important book, I think. It deals, and they've given it the subtitle, A Modern Appraisal of the Law of Squatting. Now, Elizabeth and I have talked about the book. Let's have a look at it first of all. There's the front cover. There's nothing on the back, basically. It's listed as being part of law and sociology. I think that's probably true to a certain extent. Criminologists will find this quite interesting, I think, as well. There's the front cover itself. Then we go into the three parts in total, parts 1, 2 and 3. I'll mention those in a minute. 9 chapters in total and a conclusions chapter at the end and an index. Then there's acknowledgements. Then you go straight into a list of all the people who've contributed. A large number of people involved because obviously it's been edited by the 3 people I mentioned earlier. Then you have table of cases. Then some European legislation, and then you go straight into the introduction. And this talks about section 144 of LASPO, the Legal Aid Sentencing and Punishment of Offenders Act. I call it LASPO 2012, now in force. There's the index at the back. You've also got very useful conclusions, which is certainly worth looking at, developing critical perspectives on squatting. And then, of course, you've got, what you do have is you do have footnotes, which are very helpful. You have, again, subtitles, no paragraph numbering, but again, lots of footnotes. And I thought this was a first-class book, right in the middle of it, The Role of Rhetoric. Now, I'm sure that many people will come to this with different views about squatters and squatting. Obviously, I've dealt with these cases at the bar, and they are difficult. The law has been unclear for centuries. And of course it's only recently that the law has been changed. Let me talk about what Elizabeth and I have felt this book is about and why it's of value, certainly to anybody involved in this area of not so much housing law now as criminal law, because obviously it's now a crime. The 3 authors of this book, I've mentioned their names, Lorna Fox O'Mahony, I hope that's pronounced correctly, David O'Mahony and Robin Hickey, were members of the Durham Law School, where papers on this subject were presented to a workshop. Since the workshop presentations, the papers have been revised by peer reviewers, always a good idea, and the end result is an important turning point in the practice of unlawful occupation since the passing of section 144 of the Legal Aid Sentencing and Punishment of Offenders Act 2012, or LAPSO. They call it LASPO. They call it LASPOA. But we actually, at the bar, we actually call it LASPO, which is the easiest way because we've had to deal with the legal aid aspects in some detail. Anyway, this is specifically about squatting. What we found remarkable about the book was its depth and the amount of research which has gone on after years of indecision and political stalemate on what to do with the squatter. There are 11 contributors who've each offered constructive insights into what is clearly for some a moral issue, combined with a certain amount of rhetoric on both sides of the debate. And to many observers, section 144 could not come into force quickly enough, and to others, the subheading Vulnerable Demons may well spring to mind as a fair description of unlawful occupation, unless, of course, you have been a victim of a squatter yourself, in which case you may feel rather differently about squatting. We make no comment on either side of the debate, except to say that a balance has been achieved, we think, by the editors here to produce useful jurisprudence on an issue which has bedeviled generations of politicians until 2012. And let's face it, if you look at the history, it goes back to the Middle Ages and earlier, when in fact it was originally an offence and then it became civil. The book is 250 pages long and split into 3 parts. Part 1 covers the state, critical perspectives on criminalisation in the neoliberal state. Part 2 covers the squatter, vulnerability, lifestyle, protest and political rhetoric. And Part 3 covers the landowner, protecting property and adverse possession. So you see the balance is there. It's looking at the individual compartments that make up the problem, if I can put it that way. We suppose it's fair to say that the criminalisation or the criminalising of squatting was on the cards for some considerable time, and yet it has taken a Conservative and a Liberal Democrat coalition government to bring it about. Interesting. Don't think you'd have possibly got it with the Labour Party, but we'll see what happens after the 7th of May 2015. Read the introduction and then skip to the conclusions by the three editors before you immerse yourself in the detailed content by the contributors. As the editors say, the book offers a range of scholarly perspectives on this new offence, which has transformed a civil tort of trespass into a crime, and the implications are profound for both substantive law areas. This book is an absolute treasure, in my view, for both teachers and students interested in the basic jurisprudence of where a tort ends and a crime begins. We've always had that problem, and whether in the 21st century the law of tort has as much relevance today, when the state can deal more effectively with a trespass than the civil courts have done in the past. We're actually talking money, and of course the state is paying rather than a private individual. Just bear that in mind, because that's always the problem with the civil wrong as a tort. The answer, of course, is that it makes the position of the landowner more secure, and that gets to the very roots of the history of English common law from its earliest days. That's clearly what Parliament wanted to do, and it is doubtful whether there'll be any going back or repeal of section 144. We'll see what the manifestos say, although there may be calls for such repeal in the future, as some may see the state overreaching itself. It's a balance. I don't know what will happen. I doubt very much whether it's going to be pretty high on the agenda, frankly. The final word goes to the editors, who sum up the position nicely. Quote, "This collection offers a lens through which to view the impact of this changing political environment on law and policy." And there's probably more of this to come as the century unfolds. So thank you, Routledge, and the contributors and editors for publishing such an excellent book at such a pivotal moment in English legal history. It's actually quite readable, although it's at a relatively high academic style. It's a readable book, and I think anybody involved, certainly undergraduates, anybody who's on the bar course who may do or deal with this sort of area of law, certainly in the bigger cities, should bear this book in mind. So thank you to all concerned and to Routledge for an excellent title. Bye-bye.